My name is Dick Silverman. I am the co-chair. Where did Steve go? Along with, well, Steve Savage is my co-chair on the Public Policy Committee for the Institute. On behalf of the board of the O'Connor Institute and our CEO, Sarah Suggs, I want to welcome all of you here tonight and want to provide some thank yous. First to Dean Doug Sylvester of the ASU Law College, to our distinguished panelists, and they'll be introduced in a moment, but Stanton Jones, Joe Canfield, and Mary O'Grady, and our moderators, Steve Goldstein of Phoenix NPR affiliate, KJAZ. With respect to those of you who would like to receive continuing legal education credit for tonight's program, the certificates will be available at the check-in desk after tonight's program. We will have a Q&A session. There are index cards available. If you raise your hand when you have a question, O'Connor Institute staff will provide you with the card and then pick it up. Finally, I want to introduce tonight's moderator. As I said, Steve Goldstein. Steve has been with the local NPR radio station KJAZ since 1997. Over the past 20... I'm sorry? Didn't we all? Over the past 23 years, he's interviewed countless guests on a multitude of topics and hosted programs including Here and Now. And Steve is the current host of the KJAZ NPR program, The Show. And with that, Steve, I'm going to turn it over to you to introduce the panelists.
Thank you, Dick. Thanks, everyone, for showing up. I know there's a Bernie Sanders event, so thank you for not going to that instead. We appreciate that. Yes.
Is it?
I guess I should know how to do this as a professional. Is the mic hot now? Yes, it is. Thank goodness. All of you missed my Bernie Sanders joke then. Too bad. Starting with the panelists closest to me, we have a distinguished panel. R. Stanton Jones of Arnold Porter in Washington, D.C., and he is a great choice for this panel. He's one of the attorneys who headed up the successful redistricting litigation before the Pennsylvania Supreme Court. He recently has handled trial and appellate litigation involving the First Amendment, the Foreign Sovereign Immunities Act, the Alien Tort Statute, and the Federal Deposit Insurance Act. And he has also represented parties or served as an advisor in 16 cases before the U.S. Supreme Court. Stanton Jones, thank you for being here. And next to Stanton, we have Joseph Canfield, who is the Chief Deputy and Chief of Staff for the Arizona Attorney General's Office. Legal expertise includes election and campaign finance law, constitutional law, civil and appellate litigation, administrative law, consumer and state and local tax matters. We will be talking about none of those, Joe, sorry. He previously served as state election director for the Arizona Secretary of State as well. Joe Canfield, thank you. And we also have Mary O'Grady of Osborne Maladon in Phoenix. Her areas of expertise include election and campaign finance law, along with the Voting Rights Act, state constitutional law, government contracts, state legislation, open meeting and public records laws, and redistricting. She was also Solicitor General for the state of Arizona and has represented the state in a variety of complex, high-profile lawsuits, including 10 cases before the U.S. Supreme Court. Mary, thank you for being here. So to let you behind the curtain a bit, we were trying to figure out how to start this, and we are going to start with a primer as much as we can. Stanton, I'm going to ask you to do this for us. In terms of the impact generally of the census, why is it so important when it comes to redistricting and congressional districts?
Absolutely. Thanks, Steve. So the census, which is conducted every 10 years by the U.S. government, is a count of all of the people in the country. It's used for a couple of very important purposes. Census data is used, for one, to distribute billions of dollars in federal funds, and additionally, census data, the count of the population, goes a long way towards determining the balance of political power in the United States. After each census, the census data is used first to allocate all of the seats in Congress, in the U.S. House of Representatives, among the states. So each state gets a certain number of representatives in Congress based on its population from the latest census. For instance, Arizona currently has 9 seats, but because its population has grown in the last 10 years, there are some predictions that Arizona will pick up an additional seat, and after this next census will have 10 seats in Congress, so additional political power for Arizona. And then secondly, the census data is used within each state when the states redraw all of their election maps, and that includes both their the maps for their congressional districts, as well as all of the state's maps for the state legislature, so state house and state senate districts. And every state does that. They redraw all of those maps every 10 years because, under the law, all of the districts need to have the same population. They need to have the same number of people. That's what people mean if you hear people talking about the rule of one person, one vote. A central part of that is that all congressional districts, and with a slight allowance for some population deviation, all state legislative districts need to have the same number of people, and that is based on the census data also. So for instance, just pick any geographic area in the state. Say the population of Tucson has gone up in the last 10 years. I don't actually know if that's true or not, but under the new election maps that would be drawn, Tucson then might have an additional congressional seat or an additional seat in the state house. And again, that would be based on the latest census data. So for both of those reasons, the allocation of congressional seats among the states based on census data, and also the redrawing of congressional and state legislative districts within a state based on census data. For both reasons, you can see that that census count is just critically important to distributing political power nationally and within a state.
And the great majority of states, unlike Arizona, have lawmakers deciding on the district. Explain that briefly for us, and I'll let Joe talk more about the IRC here.
Correct. So the U.S. Constitution says that the legislature of each state gets to draw the state's congressional districts. And in most states, that is the case. The General Assembly, the state legislature, enacts a redistricting law. It's a state statute that describes in geographic terms the boundaries of each district, and that's typically true for both congressional districts and state legislative districts.
Joe, you and Mary were heavily involved with Arizona's Independent Redistricting Commission the last time around. Just remind people of what the IRC is and what it's supposed to do.
So I guess the IRC is the Arizona Independent Redistricting Commission. It is a constitutional body that is created of citizens whose sole purpose is to draw the congressional and legislative maps every 10 years. And Mary and I have had the pleasure of serving as co-counsel for the commission this last decade. But I'll give you just a little bit more background, and I'm sure Mary will fill in whatever I miss. But before 2000, the maps were drawn by the Arizona legislature. Some people liked that process and some people did not. And Mary actually worked in the legislature, so had seen it firsthand the way that it was done before the commission was created. But it was, as Stanton mentioned, it was done through legislation, but the process itself of coming up with the districts, there was a lot of barter and back and forth. Some of that was done in public, some of it was done behind the scenes. So I think the citizens wanted a more transparent process, and so what they did was they exercised the the right to propose an amendment to the state constitution, which we can do here in Arizona by circulating petition signatures, and they put what was called Proposition 106 on the ballot in 2000, and the voters approved that measure, and what it did was it created this commission, a 5-member citizen commission, like as I mentioned, who's tasked with drawing these lines. It specifically says in the preamble to this act that it was done for the purpose of removing that process from the legislature. And it tasked the commission, it set forth a very detailed process that we can get into perhaps later, but generally what the commission is supposed to do is start from a clean slate. It doesn't look at the map as it existed before. It doesn't look at where incumbents live. It's told by the Constitution to focus on things like geography, keeping the districts compact. These are so-called traditional redistricting principles, trying to keep cities and towns whole, counties whole, and to the extent practicable, creating competitive districts, which is somewhat unique in that this goal of competitiveness is now embodied in the Arizona Constitution and has created some litigation the last go-around. The commission itself, I mentioned, are citizens, so they are appointed. People apply, and you all may or may not be eligible to apply. That process is going to begin probably around December of this year. You apply to the Commission on Appellate Court Appointments, so that is the commission that selects judges, screens people who want to be judges on the state appellate courts, the Arizona Court of Appeals, the Supreme Court, and they interview, screen, and then present a balanced list to the governor. So those that drafted the redistricting provision thought that, well, this commission is already in the business of screening applicants for the high court. Why not give them the same process of screening applicants for the commission? So they do. So people apply to the commission. There's some prerequisites. You have to have been affiliated with a political party for at least 3 years before, or unaffiliated for 3 years before. You can't have been a paid lobbyist. You can't have been held a position in a campaign. So they, obviously you can kind of see what the drafters were getting at. They wanted to try to get people, not necessarily people that were nonpartisan, but folks that maybe had some disconnection from the political processes. And we can debate whether that worked or not, but once people apply and they meet the criteria, then that commission then presents lists to the Arizona legislature. So the leaders in the Arizona House and the Arizona Senate get to select who they want. And I say leaders, meaning the majority and the minority leader, and so first it starts in the House where the Speaker gets to pick a person, then the minority leader gets to pick a person, then it goes to the Senate. So you end up with 4 people who are going to be, practically speaking, are going to be 2 Republicans and 2 Democrats, given, I say that as someone who teaches election law, that that of course could change, but in our lifetime that's probably going to be how it's going to be. Once those 4 people are assembled, then they pick the chair, and the rub is the chair cannot be affiliated with one of the parties that the other 2 are. Does that make sense? So it basically means that the person has to either be unaffiliated or an independent, or affiliated with a party other than the Republican or Democratic Party. So given that roughly a third of the voters in Arizona are unaffiliated, what we've seen, the last 2 chairs of the commissions were independents. They weren't affiliated with any party. The only other thing I can think of that maybe I forgot was that no more than 2 of the commissioners can be from the same county, if I recall correctly. Is that, of the 4, but the chair can be of the same county. So, and that last commission, we ended up with 2 of the commissioners from Pima County, and then the chair was also from Pima County. So to answer my own question. So that's essentially the process, how the commission works, and that's all going to start, again, as I mentioned, in December. The commission will be up and assembled, if everything goes as constitutionally designed, by the end of February, and they'll be off and running by March and drawing maps by the late summer. So,
well, Mary, this is a big question, and so let's try to make it, I'll answer brief, and we can move on here. But Joe mentioned the 2 of you were co-counsels for the IRC. There really wasn't any need for attorneys there, right? Because no one was really upset about this political process in any way, right?
Yeah, we don't really have much to do. We sit back.
But just briefly give us a review of the sort of disputes that people had with the system, and what was there some sort of consistent tone to it? Was it that, because we have heard that the first cycle Republicans did well, the second cycle Democrats did well. Is it predicted based on the party that doesn't do as well was bringing suits, that sort of thing?
Well, this decade, I guess we're still in this decade. No, last decade, in 2011, the litigation started before the commission was appointed. If that is any kind of sign of things, how things might play out. The first lawsuit filed was in the midst of the process that Joe is describing, when the Speaker of the House and the President of the Senate sued the Appellate Court Appointment Commission and challenged 3 of the members on the list as to whether they were qualified to serve. And that was a special action at the Supreme Court, and the Supreme Court ended up eliminating 2 irrigation district members because they were public officers who were not qualified to serve, and then did not strike actually a law professor, Paul Bender, and he was challenged because he was a tribal judge pro tem. And the question was, is that a public officer who can serve? And the court said, that's okay, irrigation district members, no. So they had to go back and do over. So that was the first lawsuit. Joe and I handled that when I was at the Solicitor General's office. And then it was very contentious. And there were we had 2 lawsuits during the process. One was an open meeting investigation by the Attorney General that turned into litigation in the summer, so right in the middle of the process. And then, as some of you may remember, part of the process is that the commission adopts draft maps, and then those maps are out for a 30-day period of public comment before the commission can come back and adopt things. And that's part of trying to have a more transparent process that the public is involved with. That was part of the effort of this constitutional amendment. So toward the end of that 30-day comment period, the governor removed the commission chair with the ratification of 3/4 of the Senate, or 2/3, I forget the vote. And so we went to the Supreme Court to get the chair reinstated, challenged that the constitutional standard for removing the chair was not satisfied, and the court reinstated the chair. And so that's during the process. That's before the maps are done. When the maps are done, we have 3 more lawsuits, one by the legislature itself challenging the commission's authority to do congressional redistricting based on some of the language that I think Stanton described, where in the election clause it says, the time, place, and manner of election shall be determined by the states through the legislatures thereof, or something along that. So it says legislature, and the question is, can you even have an independent commission do this, or does it have to be the legislature? So that was one. We won, and then we had another one, a challenge to the legislative maps and the population deviations in the legislative maps. The challenge was there evidence of bias, political partisan bias, favoring Democrats in the population deviations. And then the third lawsuit was a state court lawsuit challenging the congressional map on procedural grounds. So we had 5 lawsuits, and I will brag. Joe and I, the commission prevailed on all the litigation that was filed, but the last lawsuit ended in 2007. The previous decade, there was one big lawsuit, and that ended in 2009. 2017. In the previous decade, it ended in 2009. So it was a lot of litigation, and then beyond the litigation, it was, as some of you may remember, a very contentious process.
I was telling the story before we started here when I was with the governor's office before I went into private practice in 2011, and the redistricting commission, when they put out a proposal for council, Mary and our firms both applied, a number of other firms applied as well, and when we were fortunate enough to have been awarded the contract, my partners, a couple of them were here, one of them specifically asked, is this going to generate any litigation? And I said, yeah, I think so.
So Stanton, let me ask you, when you hear about the IRC and what went on in Arizona, you've been heavily involved in gerrymandering cases, we'll call them, in Pennsylvania, North Carolina. Before we get into those specific cases, as an observer of the systems, just heard talk about the IRC, I know you've looked into that a bit as well. How do these different systems compare? Does an IRC, we just heard it's as ripe for lawsuits as anything else. How does gerrymandering affect what's going on in these other districts? Is gerrymandering impossible in an IRC situation, or is it just a different sort of legal machinations there?
So, yeah, the cases I've done are partisan gerrymandering cases, which is when whoever is drawing the district lines manipulates them in order to create an advantage for one political party. And sort of at its extreme, partisan gerrymandering can be done to really to predetermine the outcome of particular elections. You know, you can say to a very high degree of confidence, a Republican or a Democrat will win this seat every single time for this entire 10-year cycle. When redistricting is done by the state legislature, as it is in most places, as it was here before the independent commission was created, it is incredibly political, right? You're talking about one statute that is going to determine in a huge way what's the partisan makeup of the state's congressional delegation and which political party will control the chambers of the state legislature for a decade. And with so much partisan politics at stake in the state legislature, it is just inherently an incredibly political process, and gerrymandering occurs most prominently when there is a single party in control of the entire state government, right, of both the state house, the state senate, and the governor's office, because they can then band together to gerrymander the maps for their own political benefit. In the context of the commission, both in Arizona and there are a handful of other states that have commissions, each of them is slightly different in terms of how many people there are, how are those people selected, what are the criteria that they're supposed to use to make the maps. But certainly the fundamental idea of it is to take that politics out of the process. And I think in the Arizona Commission, you can see it most centrally in the manner in which the fifth commission member is selected. So you get 2 Democrats, 2 Republicans, and they have to pick essentially the tie-breaking vote. And it has to be someone who's not a Republican or a Democrat. And I know that there have been reports here that, you know, in one particular cycle, people think that Republicans did better in the commission, and in the next cycle, people think that Democrats did better with the maps that the commission drew. But when you compare the partisanship that goes into the maps drawn by an independent commission like Arizona's versus maps that are drawn by actual partisan elected officials in the state legislature, it's night and day.
And in these other states, you're almost having lawmakers drawing their own districts for themselves.
Right, and so that's why the sort of cliche about partisan gerrymandering is that it's the elected officials picking their voters rather than the voters picking their elected officials, because, right, you have the state legislators potentially drawing their own district and trying to draw in people and communities that they believe will reelect them.
So considering you've been involved with Pennsylvania and North Carolina, are there other states that are dealing with the same thing as we enter this new census, and we're going to have even more of this? Are you expecting there to be more suits that may come before the Supreme Court?
So there certainly will be no shortage of gerrymandering and other litigation, right? With so much political power at stake, it's what just feeds litigation after litigation. You talk about the cases ended in 2017. We just had a gerrymandering case in North Carolina that ended in December of 2019. So that's about as long as you can stretch it. The U.S. Supreme Court actually decided a case involving North Carolina's congressional map this past summer, and the U.S. Supreme Court ruled that federal courts can have no say, cannot even hear, don't even have the power to hear cases challenging partisan gerrymandering. So that is now the law of the land in all of the federal courts across the country. So to the extent that people want to bring partisan gerrymandering lawsuits going forward to challenge the maps and say these maps were manipulated by the map drawer for partisan advantage and it's unfair, these are effectively rigged elections, they'll need to bring those cases in state courts under state constitutions. And that's what we did. We sort of started that process a few years ago in a partisan gerrymandering challenge to Pennsylvania's congressional districts. It was 2017 at the time when we were sort of trying to decide whether to bring the case in federal court or state court. We predicted at that time that the U.S. Supreme Court eventually would say that federal courts have no business hearing these types of cases. And so we went to state court. That is now the only avenue that exists.
So it's probably worth maybe fleshing out the partisan gerrymander issue just a little bit, because I think the only thing I agree with everything Stan said. The only thing I guess I would take issue with is the way I read the cases and the case from the U.S. Supreme Court, I wouldn't say that they say they have no business. They declared it at what they call a political question. In other words, the court kind of threw up its arms and said, we just don't know what standards we would apply to a claim made by someone who believes that their vote has been diluted by the fact that they live in a district that's been arguably gerrymandered to favor one party or another. So maybe to put it in terms that maybe more real would be if you're a registered Democrat and you live in a district that's dominated by Republicans, where you can't vote in the primary, where essentially that's going to be where the election is decided. You may feel like your vote has been diluted or you don't have a say, and those were those claims were grounded in the Equal Protection Clause of the United States Constitution on the thought that in that situation, if it's done in such a way where it's clearly gerrymandered, you can't tie the shape of the district to more traditional redistricting principles like geographic boundaries and the stuff I talked about earlier, city and towns, and just drawn for the purpose of gerrymandering to advantage one party over the other, then there would be a claim. But the courts struggled for years. The first time this ever really was declared to be a justiciable claim was in the 80s in a case of the U.S. Supreme Court called, I think, Bandemir was the name of the case. But the court still, while saying, well, we will entertain an equal protection claim of partisan gerrymandering by someone who believes that their constitutional rights have been violated, they still didn't strike the map down that was at issue because they didn't agree on the standard even in that case. So they let the lower courts kind of flesh out the standard. And they thought we might have a standard. About 10, 15 years ago, they thought that the court was going to declare it non-justiciable, but Justice Kennedy saved it, and he said, well, I'm not ready to go there, but I'm not ready to recognize what the standard is. So try again, lower courts. And they tried again. They came up with something that people thought would be a metric that you could use based on wasted votes or votes that weren't, if somebody is able to get elected with more votes than they need, then maybe you could use that to measure that it's really been gerrymandered. So, but in this case, the Rucho case that Stanton mentioned, the court threw up his hands and said, you know what, we're just going to declare it non-justiciable. So as of right now, there is no federal claim for partisan gerrymandering. You cannot go into federal court and argue that your rights have been violated. But the state court-based claim is, maybe the new frontier and that's maybe something we should explore a little bit.
Mary, did you want to talk about that?
Well, I guess putting it in for Arizona with the commission, I don't see partisan gerrymandering as a threat here. Maybe others would think I'm naive, but I really don't. I think that we have constitutional criteria that the commission has to apply in adjusting the maps, and there's a lot of deference to how the commission goes about doing its job. But with the appointment process and just, I really think, and the whole process, I think really the kind of partisan gerrymandering that Stanton's been litigating I don't think we see here. And also with a constitution that has the directive to favor competitive districts. And so but, you know, it doesn't mean someone might try to sue, you know, here, but I don't view it as a big threat here for our state level lines. In other jurisdictions who don't have this type of reform with the criteria, and I think that's part of what the court said, you know, let's look at these other, you know, states, figure it out, kind of, because federal courts, we don't see this as an appropriate issue for us to resolve, but they kind of threw it back to the states. So whether it's, you know, the litigation through state courts or other types of reforms or
commissions like, didn't they cite, we were talking about this, the majority looked at commissions like, although they didn't cite Arizona's commission,
Yeah.
they looked at other commissions and said maybe this is the better way to deal with the partisan gerrymander, because every justice expressed concerns about partisan gerrymandering. That's the irony. As you read these opinions, they all, you know, seem to agree that this is not a good thing. It's not good for democracy, you know, to have, you know, map drawers behave in this way, but they just didn't want to be the ones to arbitrate those disputes.
And I sometimes wonder if like the legislatures who do have, you know, the authority to do whatever they want within, you know, one person, one vote requirements, but do the kinds of things that you saw in some of the states that were challenged, whether at some point the legislatures and the governor who signs those bills will be shamed into like, you know, we shouldn't, let's do this just through some public reaction, but that hasn't happened, and the power of this process is so great. It's, I think it's so tempting for those in power to do what they need to maintain power. So it'll be interesting to see, now that they know the courts aren't going to be there, the federal courts aren't going to be there on this issue, how that plays out next decade.
Well, as Stanton said, it stays in effect for a decade, so that explains why we see this political fighting. But one more question related to Arizona. Yes, the IRC is less political, but this is a process where it's impossible to take the politics out. Is that correct? Because even though a fifth member is an independent per se, we saw the last chair criticized for actually having Democratic leanings. So is this as close as we can get to taking out the politics?
In my view, the thing it does take out from the process is the self-interest, because that's gone. You don't have commissioners drawing their own maps. You don't have commissioners drawing the congressional district they want to run in. And so the self-interest is out of the process. And in terms of politics, you have a 5-member body making decisions, so you have whatever, you know, I don't know if that'd be small, whatever you would call that, in terms of how they make group decisions, you know, in the public, through the public meeting, but there's still some group dynamics in terms of getting to 3 votes to approve something. And so there's that kind of politics that you see on any public body. And then there's politics in the community coming to, knowing that these 5 people are going to make these decisions that are important to a lot of folks who don't get to make those decisions. And so they, you know, will come to the hearings and say what they say. And so there's whatever politics in the community to try and affect the process through their testimony or whatever it might be. Or their lawsuits.
Right, and there's still involvement by the legislature. I mean, I'm sure if you talk to leadership in the legislature, they would take issue with that. But as I mentioned, you know, the legislative leaders appoint 4 of the 5 commissioners. The legislature also is entitled to opine on the maps, as I recall from the Constitution. And then we saw the legislators come to the commission meetings and comment at different times, you know, about the communities of interest and other issues. So there's that. But the only thing I would add to what Mary was saying was that this was a very transparent process. I mean, those that drafted this up wanted this all done in open, and the only time we could really ever go behind closed doors is if we were talking legal issues or getting legal advice. And even then, this commission really bristled at going behind closed doors. So Mary and I ended up having to give a lot of legal advice in open session, which we didn't love doing, but we did. And then everything was being transcribed. So every single meeting of the commission, I think the website may still be available. You can go and you can read every transcript from every meeting of the commission, every public hearing that they held, and they held dozens of them around every corner of the state. So, no one can criticize the process for being behind closed doors.
Is there an audiobook version of that, Joe, in case we don't want to read all of it?
There are videos.
There's
not
videos,
online.
you can watch the videos.
I remember being at a meeting, and because they live stream the meetings, and they had a ton of meetings. They had their business meetings, they had public input meetings across the state, and I remember being in a meeting and some woman I've never met says, "Oh, you got your hair cut," and it's because she watches me on the live stream. I'm like, really? They feel like they know you after a while.
Stanton, I want to come back to this enormous question we haven't discussed yet, which could have affected Arizona greatly, and that is the so-called citizenship question that the Trump administration wanted to have on the census. First of all, explain what that would have been and where that stands now.
Yeah, so as I started out saying, the census, which the U.S. government conducts every 10 years, is a count of the total population in the country, all of the people, regardless of their legal status or anything else. What the Trump administration proposed to do was to add a question to the census about your citizenship, whether you are a citizen. That posed a couple of very serious concerns. The first is that it would potentially deter a large number of Latino people from participating in the census, right? People who have concerns about providing information about their citizenship to the U.S. government. And if the citizenship question essentially scared people off, it would lead to an undercount. So it would not accurately count all of the people, and because billions of dollars of federal money, as well as political power, is distributed based on where people live according to the census, communities in which there is a significant undercount would receive less federal money than they should, and they would not have the same political representation in either Congress or the state legislature. Separate from that concern was a somewhat more complicated use of the census data, but ultimately the idea is that some states have and people have proposed doing redistricting, that is drawing the districts to have the same number, not of people, not the same number of people according to the total population, but the same number of voting age citizens. And so limiting political districts to what's called CVAP, citizen voting age population, instead of using the total population to create districts. And it turned out that if you did redistricting, if you switched the way that redistricting is done from using total population to using citizen voting age population instead, it would be enormously advantageous for Republicans. And a few years ago, there was a case where went to the Supreme Court where people had proposed doing this, and it was ruled essentially not to be permissible then, but the court suggested that if you had census data that differentiated between citizens and non-citizens, then it would probably be okay to draw districts based on citizen voting age population. And so that was a significant reason why the administration wanted to add the citizenship question. They wanted that citizenship census data in order to be able to draw political districts in this using citizens instead of the total count of all people, because this would be, it's hard to even overstate how advantageous it would be for Republicans.
Mary, how big a concern would that have been from a legal standpoint? And Joe, chime in on this as well. I mean, Arizona being a border state, that certainly would have been a concern, could have affected the 10th congressional district being added, that sort of thing.
Well, two comments. One, part of our state constitution is that they have to be of equal population. And so I think there's probably a good argument that, again, we as a state are looking at total population. But theoretically, it would be huge, not just the border issues, but even thinking like the senior communities. If you look at how that affects areas with seniors versus areas with families, because you're only doing, the only people who count are people of voting age. And so it would just dramatically change everything about our state politics.
I should add, the Supreme Court threw out the citizenship question. It struck down the citizenship question in a case that I worked on this past summer. The court, the government said that it wanted to ask about citizenship on the census in order to improve Voting Rights Act enforcement. That is to essentially to protect and enhance the voting rights of minority communities. And the Supreme Court, in a 5-4 decision this past June, said that that Voting Rights Act rationale was a pretext. That wasn't actually why the administration added the question, and it's illegal, essentially, to lie about why the government is doing something.
Well, and maybe that's a good segue to talk about the Voting Rights Act.
Okay.
If you, I think
Please,
that was that
absolutely.
next on your list?
Absolutely.
Only because it plays an important role in how these districts are drawn, especially in Arizona. I'll do my best to give a very high-level overview, and maybe Marion Stanton can fill in the blanks. But the Voting Rights Act requires that that certain groups in Arizona, Native American, Hispanic groups, and other states, African American groups, their votes not be diluted. I mean, there's the more technical legal way to say it, but if they're a cohesive group that are compact and vote generally as a whole in favor of the same candidate, and the non-minority groups vote against their candidate, then they are entitled to some protections to be kept together when districting. Up until a few years ago, Arizona was a covered jurisdiction under Section 5 of the Voting Rights Act, which meant that we couldn't make any change to any voting practice or procedure without getting approval from the Department of Justice or by a federal court. But and Mary and I had to work with the commission on this, because in the past, one map or another had issues complying with Section 5 of the Voting Rights Act. So, and this commission had set out a goal of getting its maps approved or pre-cleared without any objection. And so we were able to navigate them through that process. That required that, I believe on the congressional map, that they draw at least 2 districts that where Hispanic voters could elect their candidate of choice, and on the legislative map, I don't even want to. Yeah, I don't even want to. It was a few. There's 30 districts, but so since this districting, the United States Supreme Court struck down the coverage formula that triggered coverage of Arizona and every other state of the Voting Rights Act. So Section 5, even though it still exists, the coverage formula that covered a state that was in Section 4 is now gone, essentially, until Congress comes up with a new formula, which means that the next districting in Arizona won't have to deal with Section 5. In other words, they won't have to get pre-approval or pre-clearance, and that really drove a lot of the process and the timing, because we had to get these maps done and pre-cleared in time for obviously the 2012 elections. And but that doesn't mean that these racial considerations go away. It just means they don't have to get pre-clearance. But there's still Section 2 of the Voting Rights Act, which says that it's Section 2 of the Voting Act comes from the 15th Amendment, which says that you can't discriminate against anyone's right to vote based on race or color. So it essentially means that if there is Hispanic voters in Arizona that vote as a block, and again, vote for a candidate of choice over the wishes of the non-Hispanic population, then those districts are going to have to be drawn again to allow those populations to elect their candidate of choice. The same is true of Native American voters to a certain extent, although the population isn't large enough to justify like a congressional district, but it does impact the state map. So I think that will be an interesting dynamic to see how that plays itself out this next redistricting, how the commission wrestles with making sure that they don't run afoul of Section 2 of the map. And so, but again, a very important consideration, and it's in somewhat, it restricts the flexibility of the commission in terms of how it draws these maps, because it has to keep these voting groups together.
And I'll just add, sometimes the interesting challenge is you have the Voting Rights Act that protects, ensures that minority voters have an opportunity to elect the candidate of their choice, and they're not discriminated against in this process. You also have racial gerrymandering principles, that race is not too much of a factor, and it's not the predominant factor in redistricting.
It's a legal tightrope.
Yeah, so sometimes, so there are a couple of ways that race as a legal matter plays an important role in redistricting. And I agree with Joe, the fact that we're not subject to Section 5, and the state doesn't have that burden of proof up front, really is a significant change in Arizona and all the other jurisdictions that were subject to Section 5 previously.
I should clarify, Section 5, so basically it said that there couldn't be no, the legal term is retrogression, but what that essentially means is that the commission couldn't draw a map that put these minority communities in a worse position than they were under the prior map. So if there were 2 congressional districts that favored Hispanic voters, where Hispanic voters could elect their candidate of choice, then you couldn't reduce that to 1 without facing a potential claim of retrogression. So I think when we started with some basic principles when we counseled the commission that, here's what the map looked like before, here's what the prior commission did to comply with the Voting Rights Act, and here's what you need to do to at least maintain a minimum, and then go from there. So.
Forgive me for delving into politics too much, but even the idea, the citizenship question will not be there, but Arizona wanting that 10th congressional district, and as population movement changes, is there possibility of there being a chilling effect if people just hear about this? And is that a concern for certain states, maybe Arizona, maybe Texas, maybe California, for example?
Yeah, yes, absolutely. I think, with or without the citizenship question on the census, some of the damage was done. Because it was a big political news story for a long time, and I think part of what that accomplished is creating a culture of fear around the census, so that even though the Supreme Court struck down the citizenship question, the census is starting now, and there is no question at all about citizenship on it. No one will have to answer that question. I think nonetheless there's a great concern, and there's actually some data to support that just all of the news about the possibility of a citizenship question may have a deterrent effect for these affected communities, which would be negative. I think another thing that's likely to happen is that there will be efforts to interfere or create even more confusion around the census. There have already been reports about people sending out either emails or text messages or actual paper mailers with requests to participate in a census that's not actually the census, so that people would be confused, think that they already filled out the census when they hadn't.
Joe, you're sort of the political person up here, forgive me, but as close as we get, so there's been discussion about Arizona based on how the 2018 cycle went, electing a Democratic U.S. Senator for the first time in decades. Is redistricting, based on what the IRC does and based on what the census numbers give us, could that halt Arizona's move to purple? Or, just flesh this out for us, how big an impact this can have depending on the strategic aspects behind this.
Well, I don't, it's hard to say, because for all the reasons we discussed, and the way that this commission is designed, it'd be very difficult, for the commission to structure the map in a way that would favor one party or the other. Now, I say that, but there will no doubt be allegations at the end of the process if the map favors one party or the other side's not going to be happy about it. So with a 10th congressional seat and this process and the way the population has grown, I think I don't know. I think it would probably tend to point us in the purple direction, to be honest with you, based on my view of things. But that can all change. But we're living in a very different time right now. I mean, we're seeing a lot of people participate that arguably had not before, and that's really changed. I mean, in a good way, it's changed the dynamic of how these elections are conducted and how people vote. And so I do think we're going to see a very different dynamic going forward. So.
I was going to add, one of the things that's interesting about Arizona's process is, and I think as Joe mentioned, they do start from scratch. In most states, redistricting is done by adjusting the old maps for whatever changes. But here they start from scratch. They draw a grid map based on equal population, and then they adjust for Voting Rights Act and communities of interest and, cities and town boundaries, the constitutional criteria, but it takes out incumbency. They're actually constitutionally prohibited from considering incumbent residence locations and potential candidate residence locations, which in traditional redistricting, that's kind of the centerpiece of the process often. And so it's just very interesting how, so it's going to be starting from scratch.
Yeah. Stan, I'd like to have you address that. That's interesting that a lot of us didn't know.
Yeah, so Mary's absolutely right. There's sort of, when redistricting is done by state legislatures, two of the criteria that they often consider, and in fact that play a very central role, are called core retention and incumbency protection. Core retention says that you should try to preserve as much of possible of the core of the prior decade's districts. So, right, by definition, that means that they're not going to change that much. And incumbency protection is drawing the line specifically to ensure that that you don't ever put two incumbents in the same district. You would never force two incumbents to run against each other. So each incumbent gets to have their own district where they can run as the only incumbent, and there's a huge incumbency advantage in elections, right? So so taking those things out of the process, which Arizona's commission does, you start from scratch. You don't have any core retention, so even if the prior decade's maps were gerrymandered in one direction or the other, we're going to start totally from scratch. We're not going to try to preserve any of the prior decade's districts, and we're not going to protect the incumbents. I think you said they don't even consider where the incumbents live, which is just a night and day difference between what happens in the commission and what happens in other places. One of the other features of the commission that Joe and Mary have mentioned is the transparency. And I think that that's just a huge feature in terms of taking the worst aspects of politics out of the process. The most gerrymandered maps in the country were drawn by an expert map maker using sophisticated computer software in secret in an office or even in his house. And then the legislative leaders will get the map that this person has created completely in a secretive process with no visibility into it, and then they'll just drop that map into a bill and it will become the law. And that facilitates just the worst practices, right? So when you see these ridiculous looking districts, there was one in Pennsylvania that became famous there that was referred to as goofy kicking Donald Duck. Rather than any sort of recognizable shape, a single political district in Pennsylvania's congressional map, it resembled a cartoon of Goofy kicking Donald Duck. You're not going to have that happen when the people drawing the maps are doing it in some sort of open session. It just wouldn't happen. And one of the cases that I worked on last year was a challenge to North Carolina's state legislative districts as partisan gerrymanders. The court there struck down the maps, but in its decision said, we're going to give the legislature another chance to draw new maps that are not gerrymandered, but they have to do it completely in public. All of the map drawing needs to occur in an open public hearing room. They need to live stream video of that hearing room with audio on the General Assembly's website. If anyone is using a computer to draw any districts, the screen of that computer also needs to be live streamed on the internet. There need to be public hearings where members of the public can come comment on the maps. And they did that. And the maps that they produced were not perfect, but they were a dramatic improvement. And I think a large part of it is, again, you're not going to draw ridiculous-looking gerrymandered districts when you're on television.
Mm-hmm. Is there momentum around the country to have more commissions like Arizona has?
More areas have been interested in it. It's a tough reform because, you know, it's hard. Arizona has it because it was an initiative. California has it because it was an initiative, and some other Western jurisdictions. So in those where the legislature where they don't have the initiative process, it's tougher to get adopted. But there has been a renewed interest in, or a lot more interest in commissions. And I forget the numbers now.
There's a lot of commissions that are report to the legislative bodies or the governor, so they maybe have the appearance of a commission like ours, but still are subjected to maybe more of the political, oversight.
I believe there are about 6 states,
That
maybe
sounds about
7
right.
states that have some form of commission. Mm-hmm. They're not all actually as independent as Arizona's is. They don't all have sort of all the same protective features. In recent ballot initiatives, I believe it was Michigan and Utah adopted
right.
independent redistricting commissions, so that in the next redistricting cycle that occurs after this census, Utah and Michigan will join the states that have their political maps drawn by some form of commission rather than the state legislature. And I do think that is directionally an important part of reforming this process and taking the rank partisanship out of it, particularly after the Supreme Court's Rucho decision that removes federal courts from policing this at all. I think that will create renewed and increased interest in ballot initiatives and other attempts to just transfer this map drawing function out of the legislature and to some form of commission.
And one thing to mention, we haven't talked about is, Congress has the power to require these kinds of commissions. And after the 2018 election, when the House swung to the Democrats, the first bill that was passed out of the United States House of Representatives, H.R. 1, is a whole Christmas tree of election reform that, in a perfect world, if the Democratic majority could get everything they wanted, is in that bill. But one of the provisions of that bill is the requirement of that there be these kinds of commissions to draw up congressional maps. That's what Congress could require. So I think it's stalled in the U.S. Senate.
We come back to politics, Ajay. Thanks for that. We're going to go to audience questions in just a moment. But so at this point, Stanton, I have to come back to you because of these cases you've been involved in Pennsylvania and North Carolina. We've all heard the term gerrymandering for decades. Are we just seeing more of a renewed effort? Were this man Thomas Hoffler and the Republican side, were they just more aggressive? And so that made more people alive to the possibility? Is that why we're hearing more about it, or is there something else?
So I think it was a couple of things. There certainly was a lack of shame. There was just a willingness to go no holds barred. I don't care how silly the districts look. I don't care how many cities or towns or counties they split up. I am just trying to maximize partisan advantage. That is my singular criteria. So that was certainly one thing that contributed to the sort of even more extreme gerrymandered districts that you've seen in more recent cycles. The sophistication of the computer software and the availability of big data, the ability to get years and years worth of prior elections data and plug it into a computer software program that you can then use to manipulate and measure the partisanship of the districts in even more sophisticated ways than ever. This is just much different than Elbridge Gerry, right, in the 1800s, sitting there with a pencil and trying to draw his district to be as advantageous for him, for himself as he could. The level of sophistication is just extraordinary.
Mary, did you want to?
I have something on a totally different topic, if you don't mind me mentioning. We've been talking about redistricting at the highest levels, congressional and legislative, but it also happens at cities and counties and school districts and a whole host of other entities. So it's something, and that all has an effect too on governance. So and all this is going to happen next year once we get the census. So a lot of important stuff.
Okay, I want to thank the panel for answering my questions. Now we turn to the audience. We have microphones if anyone wants to ask a question. Don't be shy.
It's a long walk over there. Thank you. So this may go back to the Voting Rights Act, but I'm wondering too, because there's so much racial segregation that happens in housing, is one of the purposes of the commission to undo some of the effects of that racial segregation in housing? If that's not covered on the Voting Rights Act, then how does the commission approach just redlining or other mechanisms that have kept minority groups concentrated in certain areas or away from other areas?
The commission, for doing its work, it just sort of has to take people where they are and draw the boundaries. They're not, their mission isn't to change where people are and address some of those other issues that you're describing, but whatever segregation exists, whatever else affects where people are, as demonstrated by the census, and the demographic information, that's how they have to base it work. So we end up with some areas that, for whatever, for perhaps because of historical segregation, do have a lot of, concentrated minority voters. We have other areas where there are minority voters, but they're more dispersed in the population. And then when you're looking at compliance with the Voting Rights Act, those are all kinds of things you take into consideration in your analysis. Arizona also, we have, significant Native American populations. And so that becomes a factor both in the Voting Rights Act and sort of communities of interest. So it's not a problem the commission can solve, but it may affect, what the census looks like.
You mentioned that when drawing the maps, the commission starts with a grid for the districts. Why was this method chosen instead of something like shortest split line or something else for the initial districts that they use?
Do you know?
That's a good question. I don't know the answer to that. Yeah.
It's in the Constitution.
Yeah,
That's how whoever, that's what the drafters envisioned, was starting from this grid map, and I don't know why they chose that.
You'd think that process would be without controversy, but even that generated some controversies, I recall, as to how, because if you start with a blank slate, depending on where the starting point, and whether you go clockwise or counterclockwise, and it could affect how the final map ends up. And so, we heard a lot of those arguments, and maybe that even came up in the litigation, maybe the prior.
They challenged our grid map, yeah. And also the grid map doesn't really look like a grid, because it's a grid map of equal population, which if you know Arizona's population, you can't do that in a perfect grid.
It's not nice little 30 squares. It looks a little gerrymandered, actually.
There are any number of ways that you could do it. You could do it in different ways. So in the gerrymandering litigation that I've done, one of the things that we do is we have experts who use computer technology to create computer simulated districting maps, right? So we have one expert who had his supercomputer created more simulated maps than there are atoms in the known universe. And he was able to say, based on his analysis of the partisanship of those several trillion maps, that the actual congressional map in North Carolina is more advantageous to Republicans than 99.999999999999999% of his trillions of maps. And there are different ways that the computer goes about sort of where do you start. And for like the one that that sticks with me because it's one that I'm able to understand is you just put it, the computer puts its finger somewhere on the map of the state, and that's the beginning of the first district, and the computer then just moves around randomly, grabbing essentially election precincts and adding them until you have a district that has the right number of people, and then it moves on to the next district and does this. But it's sort of a random, you just start, you literally throw a dart at the map of the state, and that's how you could start. So you could do it any number of ways, and the computers are able to do very interesting things with it.
And one of the differences in terms of the first redistricting commission and the second was the first commission did its first round of public hearings after they did the grid map and before they adjusted it. And people went nuts because they're like, oh my gosh, you've carved up the Navajo Nation and you've done all this stuff and this doesn't make any sense. And everyone was like, we know it doesn't make it. This is a grid map. That's all it is. We need to do our work. This time we had public hearings before they did that, so just to hear what people want, what mattered to people without having this thing that wasn't the final draft map, a real draft map for them to look at. So interesting how that plays into the process.
Can I ask you about a slightly different subject? I'm over here. The Electoral College. Obviously, there's a fair amount of controversy about it, and of course, it's in the Constitution. But the manner in which the states select the electors is left up to the states. So what do you think of the argument that a state that allows 100% of its electors to go to the winning candidate essentially disenfranchises the votes of the losing candidate?
Oh, that's a good question. I can think of at least two states that have tried to address that situation. I think is it Nebraska and Maine. It's not a winner take all in the Electoral College. I think they go by congressional district. So, but I'm not sure I would agree with, I think what you were saying was that is there an argument that those that are in the minority or somehow have their vote diluted because we do a winner-take-all approach on the electoral.
There's actually litigation going on now in several states where David Boyce is representing individuals challenging this on equal protection grounds that the voters who voted for the losing candidate basically have lost entirely the value of their vote.
I haven't studied that area.
It has some intuitive appeal, right? You can just imagine that, let's say that the Democratic candidate wins a particular state 51 to 49%, rather than getting 51% of the state's electoral college votes. The Democratic candidate, despite winning by only very, very narrow margin, would get 100% of the votes. And you can imagine just intuitively the 49% of people who voted for the Republican candidate might well think this doesn't make any sense. Almost half of the people in this state preferred the Republican candidate. Why does the state's electoral college system give 100% to the other person?
The only other thought I had on that is if I recall, the legislatures actually have the option on the US Constitution of appointing the Electoral College, and I think that allowing the voters to elect electors is a decision that is made by the legislature. So the legislatures in the state could grab that back if they want. I mean, there was some talk of that, remember during Bush v. Gore when there was all the controversy with the final count that the Florida legislature was just going to, discard the popular vote and just take it back. And and choose the electors. So I don't, my thought would be that, I'm not familiar with that litigation, but that would be a point of argument to defend that system, that that's how the founders of our Constitution, they didn't actually want the people deciding. I know that's a controversial subject, but there's a lot written on that, but that was pretty clear. They wanted to create this college, but so the issue that I'm most familiar with is the faithless elector issue, and I think the U.S. Supreme Court is actually going to hear that case, which is, when you elect, you're not voting for president of the United States, you're voting for a group of electors who are pledged to support a candidate. So the question is always, well, what happens when those electors show up at the Electoral College in December and they decide to vote differently? And a lot of the states, including Arizona, require that those electors vote for who they pledged, and there's penalties if they don't, and then that case that question is actually going to be answered by the U.S. Supreme Court in short order.
Steve?
Oh, thank you.
Steve, my question is for Mary and for Joe, and I'd like for you to elaborate a little bit more on the composition of the commission. I've been thinking about this one for about a decade, and my question would be, is it possible for the political leaders who make their picks, the President of the Senate and the Speaker, and the two minority leaders, to pick someone other than from their own party? Now, put to aside for a moment why would they want to do that, but if given the cast of applicants that they had before them, could they pick someone other than their own party? And if they did, would the four people who ended up having these picks, would they be obliged to take someone from an independent? Are they required to do that? Or how would they balance that? And I've never been quite clear on that, and that possibility arose 10 years ago, but it was avoided by the political leaders taking the predictable political choices from their party.
Well, there can't be any more than two of the same political party, but the House, the legislative leadership who have appointment powers, Joe can correct me, he has the language in front of him, can appoint whoever they want. They can appoint an independent, they can appoint anyone not anyone they want, but anyone on the slate that the Appellate Court Appointment Commission has presented them with. So I don't think they're restricted to sticking with their party. Joe, do you?
I think that's right. I'm looking at the Constitution right now, and I think that the Appellate Appointments Commission comes up with a list of 25 people, which is going to be most likely 10 affiliated Democrats, 10 affiliated Republicans, and 5 unaffiliated individuals, and they present that entire list. So I think when the list lands on the Speaker's desk, it's not just 10 Republicans, it's the whole list.
Can I ask a conspiratorial question then? So someone needs to be a member of a party or unaffiliated for 3 years, that was the number?
That's correct, yes.
So we have 10 years between. Do we have anything that could go on behind the scenes to make sure someone registers with a party and is not necessarily a member of that party in spirit?
Or the opposite situation,
Right, exactly.
where someone disaffiliates,
Yeah.
So there certainly, there would be nothing to prevent that from happening if someone,
Just because there's so much power at stake, as we've discussed.
right, but they have to disaffiliate, which in Arizona is as simple as just re-registering to vote and leaving the box on the form blank. And then, of course, there's other requirements I mentioned about, you can't be a lobbyist, you can't have a role in the political party, you can't be a public officer that Mary mentioned with the irrigation district. And so, yeah, I guess it's possible.
That's the first part of the question. So it's possible that political people could appoint an independent, for example. Okay, so then you have those four. Are those four then required to pick from an independent for the chairman?
Oh, boy, I don't know the answer to that question.
I don't have the language in front of me. I don't know.
Yeah, that's a really good
You
question.
say yes? I'll trust Judge Wake. He
Yeah,
says yes. They still need to have an independent chair.
We're going to go to the next question.
Yeah.
Currently, the Commission on Appellate Court Appointments only has Republican and independent commissioners. No Democrats currently sit in it. Do you foresee this being a problem for the credibility of the next Arizona Independent Redistricting Commission?
You know, that's been out in the news a lot, and, it's, you know, for that reason. And I don't know, honestly. I mean, that's a concern. That's a real concern, that the thought was, you know, this is supposed to be a bipartisan body, and now it's not because of the way the appointment process has worked. So it's a concern. Now and so to those interested in the process, since, you know, Governor Ducey and others, whoever handles that appointment process, we can't change, and the Senate confirmation can't change who's on it as a citizen, but you can, you know, follow what they do. They have their rules. That's a public process, and you can go to their meetings and follow it and tell them what you think and weigh in on candidates and participate in that process, but that has been raised as a concern, and I know they're working on it now. I think they're working on the application, and I think they might get started with that application process a little earlier, but again, you can follow their work if you're concerned, but I don't know if anybody...
Well, I mean, it's a fair question, and there's been a lot reported on this. I guess the one thing I would say is, remember, the core function of that commission is to screen candidates for the appellate courts. I've never heard anyone say that they have engaged in that process in an overtly partisan way, that the applicants that have applied for the court have been pretty good. I mean, well, I guess there's a couple that maybe
There's been some controversies.
Yeah, maybe I shouldn't say that so definitively. But I agree with Mary. I think it's really, we won't really know the answer to that question until we see who applies and we see how that commission screens folks, because, you know, these lists, they got to send 10 people from each party, arguably. I guess there's a maybe another scenario that we hadn't thought about, but and if there are very qualified candidates that are chosen over very unqualified candidates, well, then that would call into question, you know, the process. But we really don't know. I mean, I'm trying to remember how many people actually applied last time. Do you recall?
It was in the 70s.
About 70
last
people
time.
applied. So, and do you remember the split between?
I don't remember.
Yeah. So, you know, it wasn't a huge number of people, but there's certainly going to be someone who one side or the other believes to have a lot of merit, and if that person doesn't end up on one of the lists, then there's going to be criticism.
The question, I think, really highlights how much is at stake in redistricting and just how hard it is to take politics totally out of this process, right? And the citizens of Arizona decided that they wanted to get the politics, the partisanship out of the redistricting process, so they create this independent commission that's got this novel structure that's designed to create non-partisan, non-discriminatory election maps. And there's this appellate appointments commission, and all they do is whittle down the list of applicants who are able to serve on the redistricting commission to 25 people. But because of that role, the appointments to the appointments commission become political. It's like you're going to need an independent commission to appoint the members of the independent commission that appoint the independent commissioners, and you could just keep going on and on.
And in California, they've gone to a more random selection process. They have like the auditor's office, and they have bipartisan staff there do the screening process, and then it's something of a lottery once they get the pool, and then the people who've been selected from that pool select the balance of the members, so there's no legislators involved with the process and no committee screening. So that's one of the changes in some of the later versions of the commission from ours.
Bigger commission too, right?
Mm-hmm. And the other thing, sometimes in the you have bipartisan commissions, things that are designed to be bipartisan commission, like the Appellate Court Appointment Commission, but the appointment process to that is not bipartisan, unlike the redistricting commission itself. Because the redistricting commission itself is not only bipartisan, but Republicans and Democrats, you know, they may be stuck with the slate, but they have a say in who's on the commission itself, which helps, I think, although they still have the screening process.
The gentleman handed me a microphone, so I'm going to ask a few questions while I have it. But the question first is the appointments. How long is the service? How involved? How much work does it take? Is it paid or volunteer? Is that impacting who's applying? Would be one question. Another question is, we talk about the districts need to be competitive. I'm interested in what that means and how you define creating competitive districts. So that's question 2.
Can I take the first one?
Yeah, somebody gets the first. And then question 3 is, I'd like to go back to understand a little bit more about how you're using, and I don't want to say big data, but because that has connotations, but there is really rich data out there, segmentation data that we have to protect the Voter Rights Act and to be able to go in and draw polygons and see which groups of people need to be stuck together so that their voting block isn't separated. Are you using that live in this process, and is that transparent? I can go back and re-ask those questions.
I think I'll answer the first question, because that's the easiest one. Then I'll turn it over to Mary. So these, maybe you're interested in doing this. That sounds like, when these commissioners are appointed, they're actually appointed for 10 years. Now, their duties end when the final map is drawn, but technically the commission exists in current form, but it can't spend any money because it's done unless, you know, another lawsuit popped up, for example. In terms of the time commitment, it's a lot of time, and they're not paid.
Well, in the case of Colleen Mathis, she got the pleasure of being fired by the governor and not getting paid for it, so that's nice. Yeah.
Well, there's, it was a political and not the commission, but, well, it was contentious. There was a lot of people that showed up at these meetings and were quite angry with the commission and certain commissioners, at different times. But it was a substantial time commitment. These commissioners, like I said, I think there was 30 public hearings. There were several more business meetings where they had to spend a good chunk of their day. Again, all this was done in public, and other than covering their expenses, were not getting paid for it. So I know 2 of the commissioners were lawyers with large law firms, which made Mary and I wonder, how are they meeting their billable hours? And felt bad for them. Mary and I were getting paid for our time, but so yeah, I think that would definitely be something that anyone that was applying to serve would want to take into consideration. And then on top of that, even after they finished, their job, they during the litigation they had to be summoned back, and unfortunately we tried to protect them from being deposed, but we were unsuccessful, and so they had to get deposed, and some of them had to testify in court, and so it's a commitment.
Mary, do you want to take competitiveness?
For credit for?
Competitiveness? Do you want to take competitiveness? You can take credit as well.
I'll take credit for that. Competitiveness, yeah. And what is competitiveness? That's what the commission spent a lot of time arguing about last decade. The Constitution doesn't define the term, and it's supposed to favor competitive districts to the extent practicable, and it has some additional language about not doing, harm to the other criteria. And so, okay, fine. That's really what they argued about. Now, and I think different commissioners viewed it differently. The majority of the last commission viewed competitiveness as favoring districts that were sort of a toss-up, that come the general election, all things being equal, either candidate might prevail. And so that's sort of where they went, but there was debate about that. Does that mean, favoring competitive districts mean if there's a 60-40 district, you move it to, you're trying to get it to 55-45, or is that really making it more competitive or not? And so that's the kind of stuff they argued about. And
They had a series of metrics too, as I recall. They looked at voter
Yeah.
registration data, they looked at election results from, and then there was debate about that. How far back do you go? Do you go back 2 years, 4 years, 6 years? And so they had a lot of information at their disposal.
so
but-
every time they did a map for a commissioner, they would have a whole series of information, and on competitive, I think Joe said they had like 7 metrics that different commissioners said, I want to see this, I want to see that. They gave them all, and they would, and the public, that's all available to the public, and they would argue about whether they're making districts more competitive or doing violence to other principles or all the things that come into play. And the big data, I'm not sure I know exactly how to answer that question. I mean, they use the census, they use the voter registration, they use the election data, and they do all the sophisticated disaggregating or whatever to figure out how you can analyze it in the context of the new districts.
They weren't looking at people's magazine subscriptions, if that's what you're...
But it's all this sort of, you know, the Secretary of State data, the election people's data, and I don't know what else to say about that.
The technology really is quite amazing, and it's probably even better now, but as Mary mentioned, when they would do this, when they would draw these maps, the software would be on, the map would be on a screen like the one behind me, and they could tell the map drawer, who was, a consultant for the commission, adjust this line or move this community here, and then the commission would see all of the numbers pop up, how moving one neighborhood into one district or another would change the composition and the numbers of people in the district, the minority populations, the registered Democrats, Republicans. It was pretty incredible, what they could do. And some of that software, I think, is available to folks. People, I know, give Ken Clark a shout out, my neighbor. He had a mapping software that he had, and his folks had made available to people that you could draw your own map and bring it into the commission and say, hey, how about this one? And so I think that those services are going to be available to folks.
Is there an Etch-a-Sketch version as well, Joe, or no?
Is there one? Yeah.
We have time for one more question, I think, if gentleman in the middle there.
Thank you all for being here. I like that question of competitiveness. It's an interesting one. I assume that economic development is a bipartisan issue and that Arizona wants to attract as much US dollars into its Arizona economy as it can, and that states perceived to be battleground states import a lot of dollars during election years. To what extent can that economic development perspective be used as an argument for competitiveness that incents both sides to be as competitive as possible in their redistricting? Thanks.
Stanton, you want to weigh in on that one?
Yeah, I think your question also is significant in terms of the census and the incentives of the state government to maximize participation in the census. If every single person in the state fills out the census and gets counted, that maximizes the federal dollars that the state gets. You can't get any more than what it would get for its total population. And it also maximizes the state's political influence. And as we discussed earlier, this year, in this cycle for Arizona, it could mean even getting an additional seat in Congress. And I think sort of what's interesting is when you look around the country, which states are and are not devoting resources, spending money now, trying to do essentially sort of get out the vote style public messaging around the census, trying to encourage people to participate in the census. You have some states that are spending just enormous amount of state money. encouraging their their people to fill out the census so that they can get as many federal dollars as possible and as much political influence as possible. You have other states like Texas, for instance, reports that they are spending very little or virtually no money on doing that, and so it's an interesting dynamic when the state needs to choose. How much do we want to invest in making sure that our people participate?
Okay. Yes, sir. May I ask a question? Of course. No, of course.
Could you please give a quick tutorial on the timeline and cycle, census to completion, to data collection, to commission, to the map, to an election, assuming we pick up a seat and we have another member of Congress? What's the timeline?
Commission, as I think Joe mentioned, will be in place by March of next year, so right around now, we'll know who's on the commission. And the census comes out in April of next year. And last decade, and then the timeline from there is largely up to, depending on how the commission works, they have to set up an office, they have to hire staff, they have to do some of that stuff. Last decade, they got the lawyers and the consultants in place by June, and then they did the mapping work with some, interludes to the Supreme Court and stuff. They adopted the maps in January of 2012. The work was mostly done by Christmas, so it was several months of intense work. They need to have them in place for the 2022 elections, and the counties would tell people, and you need it so for candidate filing and people to figure out whether they can run. So last time the counties were saying we need to know by December, which has never happened. But since then, they've also moved up the primary and the filing deadline, and so it'll be in the heart of next year, for much of next year.
Okay. And on that note, we will thank our panelists, Mary O'Grady, Joe Canfield, Stanton Jones. Thanks to the O'Connor Institute. Thanks all of you for being here. We appreciate it.